Every day in the USA, people find themselves in court.
80 years, that's how long Texas rapper Tay-K will spend behind bars after a jury found him guilty of murder on Monday.
Tay-K, or Tamar McIntyre, was convicted for the death of Mark Saldivar, who was killed in a San Antonio Chick-fil-A parking lot in 2017. Just before 10 o'clock last night in the 187th courtroom, McIntyre stood before the judge as Judge Stephanie Boyd read the sentence.
You're still alive. You still can improve yourself. Your family can still visit you. But the complainant in this case is deceased. And you need to internalize that the complainant in this case is deceased and that his family is never going to see him again.
McIntyre was already serving 55 years for killing 21-year-old Ethan Walker during a 2016 home invasion in Tarrant County. Judge Boyd determined the sentences would run concurrently, and McIntyre can have no contact with Saldivar's family other than for legal matters.
All right, are you all ready on Tamar McIntyre?
Yes, sir.
All right.
Good morning, Judge.
Good morning. All right, the court is calling 2019 CR 12495 State versus Tamar McIntyre. Could I have parties announced?
State, John Hunter for Mr. McIntyre, Your Honor.
Are you Mr. McIntyre?
Yes, ma'am.
All right, State defense has filed a motion for new trial. Have you had a chance to review that?
I did review.
And are you ready to proceed on it? All right, so the court has read the motion for new trial. I think the motion for new trial clearly has the defense's arguments in it. So with regards to number one,
Yes, Your Honor.
any rebuttal?
Yes, Your Honor, and that, I believe that's the NCIC, TCIC
Yeah.
argument, I guess, of the defense. Our position is that we did make it available during court proceedings, and they had access to the actual TCIC, NCICs. And through our understanding of the policy is that we can't allow them to duplicate or keep or make copies of, and that's by, I believe, state orders on that. So that's our position on that front.
All right.
Megan Dowling for the state, just briefly, if I could address that point, and I want to reiterate the arguments that I made at trial, which is that 411.083 of the Texas Government Code is what governs the dissemination of the criminal histories. They were provided to Mr. Hunter, and that's stipulated to in the motion. He states that the state did provide him those. And so that is our position. It would have been a violation of law to allow him to keep them or to reproduce them.
All right, and then defense, because it's your motion for new trial, I'll give you the final response with regards to the state's answer to defense's number one.
Yes, Your Honor, and forgive me, I did not prepare to proceed today. I came to court because the law requires me to show you the motion within 10 days.
Yes.
And so I haven't, I wasn't anticipating actually discussing the merits of it today, but if the court wishes us to proceed with that, I mean, our position with respect to the NCIC argument is fairly simple. We cited you case law, which the courts have addressed this subject matter before and have recognized that it is covered by the Michael Morton Act and that it would be required to be produced. As a practical matter.
Well, you're saying produced, but the state is saying that they did produce it. They just didn't allow you to copy it or leave with it.
It was given to us on the first day of the trial. And in the process of trying to make use of it and note it down, we got into an argument about whether or not we'd be able to photocopy it, which we immediately brought to the court's attention. We had an argument in which the court concluded that we were not entitled to copies of it, which we
Does the law say that you are allowed to make copies?
I believe that that is what those cases that we have cited for stands for that proposition, that it is producible under the Michael Morton Act in all ways that other discovery is producible. The state's contention that there is a statute that privileges it from disclosure, I think, is being misinterpreted.
Okay, they're not saying, and correct me if I'm wrong, they're not saying that it doesn't prohibit them from disclosure. They're saying, yes, we do disclose it to you,
but you're not allowed to copy it or leave the courtroom with it. Am I misinterpreting what's being said?
That is their argument. Yes. Your
All right,
Honor.
so-
We just disagree with that position. I don't think the law supports it. And we also would maintain, as we maintained at the trial, that as a consequence of, well, let me rephrase that. To the extent that there is any countervailing or overarching privilege that would run afoul of the case law that we've cited, Your Honor, about its discoverability, or that would limit our ability to use it from how we would otherwise be entitled to use discovery. I would maintain that that privilege is waived by two separate independent actions. The first is this isn't a situation where we're trying to snoop on these people's lives outside of the context of defending Mr. McIntyre. He is indicted. The state made that decision. When the state or the government have a privileged interest in the privacy of certain sensitive information, and they elect to indict someone for a criminal offense over it, then they can't be in the position of being able to still hold on to that privilege. They waive it. Secondarily, they have run the TCIC and CIC for these individuals, which is the triggering event. The database is curated not by this office. It's curated by the Texas Department of Public Safety and the FBI. They query that database. They are only allowed to query that database if they have a good faith reason to do so in the execution of their duties and responsibilities as members of the district attorney's office. They can't just go pull NCIC, TCIC on you or me because they're upset with us, or they for a petty
You're
difference.
saying that they were upset with somebody, that's why they.
No, I'm giving this as an example. I have had cases in the past where I have defended policemen who were accused of improperly querying the TCIC, NCIC database for petty reasons.
So we're not saying that any NCIC, TCIC was queried without a good faith basis.
No. In fact, quite the opposite. We know that there was a good faith basis because this is the TCIC, NCIC for their witnesses. And Brady versus Maryland and every case that has come since it says that they have to give me that information. That
Okay,
is a
so
requirement.
then
So-
the main argument, and so let's stick with what the argument is. And if I'm wrong in interpreting what's being said by both parties, the argument is not that you received the information. Your sole basis is that you should have been allowed to photograph or reproduce or take the item, the NCIC, TCIC with you.
We
Is
wanted
that your?
We wanted to be able to use it in every single way that you can use.
No.
the
My
paper.
question, I'm trying to get to specifics. The specific is,
The
well,
specific,
let me start with this. Number one, was the NCIC, TCIC provided to you? Yes or no?
it was handed to me and I had about 10 minutes with it before we had to turn it back over.
Okay, so now with regards to it being handed to you, then it was handed to you. The next question is your sole objection or request for a motion for new trial with regards to point one is that you were not allowed to photograph it or take it with you. Am I correct in that?
The contention is twofold. The first problem is that we were not allowed to photograph it, take it with us, duplicate it in any way. We had to turn it back over. And as we explain in our second argument, that became an acutely problematic issue because we were unable to make use of that information to respond to the state's argument that for authenticity reasons, we were not entitled to offer Joanna Reyes's prior judgment of conviction at sentencing.
All right, so let's start with this point. First point, state, when was the NCIC, TCIC given to defense?
Prior to jury selection, Your Honor.
And the prior to jury selection, was this the NCIC, TCIC that was given to the defense prior to the jury selection? Do you remember which witnesses those would have been?
It was for all witnesses listed in the discovery.
So would that all also have included Joanna Reyes?
That's correct, Your Honor.
So you're saying that was given prior to jury selection?
It was, Your Honor.
All right. So it's the court's understanding that for purposes of cross-examination, NCIC, TCIC are considered timely if they're given before cross-examination, but my understanding is that the state gave it to you prior to jury selection. So the first question is, were the NCICs, TCIC given to the defense prior to jury selection?
A stack of paper was handed to me.
No, my question is,
I want to make sure the record is clear
I want
because
the record to
court's
be
question
clear,
is
too.
not accurate. I mean,
I want to know, they're saying that they gave the NCIC, TCIC of all witnesses to you before jury selection. And it seems your main complaint in here is regarding Joanna Reyes. So my question for the defense is whether or not the NCIC, TCIC, for all the state's witnesses, were they given to you prior to jury selection? Then we can handle your other point.
the word given is not a word that I can address in that.
Were they handed to you?
I held them in my hand for a few minutes. I didn't have an opportunity to digest their contents fully. I wasn't allowed to copy them. Almost immediately afterwards, I was told that their position was going to be that I wasn't going to be allowed to copy them. I had to instruct my
Okay, so
staff.
here's the thing.
Let me just finish real
No,
quick.
no, 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 no.
You know what?
No,
I need to-
because
I
no,
need to
stop. We're taking it one point at a time. My first question is, were they given to you prior to jury selection? It seems that your answer to that is yes. Then we'll get into what you were not able to do with them. So the record is clear. My understanding from you is that witnesses who are going to testify in the state's case in chief, their NCIC, TCIC was given to you prior to jury selection. Now that that's been established, then the next question becomes, what were you able to do with the NCIC, TCIC that was given to you?
Nothing.
All right. So you said, were you allowed to elect, because in your motion, you say you were not allowed to electronically duplicate. Were you allowed to electronically duplicate them?
No,
Were you allowed to copy them?
no,
Were you allowed to photograph them?
no.
And I'm taking that straight from your motion. So state, with regards to the NCIC, TCIC that was handed over to the defense, you're saying it was all of your witnesses in the case in chief.
Yes, Your Honor.
The defense is saying they were not allowed to electronically duplicate, copy, or photograph any of the NCICs, TCICs. Now, why were you not allowing the defense to either electronically duplicate, copy, or photograph the NCIC, TCIC?
Because I didn't want to be charged with a misdemeanor offense.
All right, and where are you obtaining that from, the fact that you would be charged?
Your Honor, I previously stated, there are two subsections of law that govern the dissemination of criminal histories. The first being Title 28, Part 20 of the Code of the Federal Regulations, and then the second being 411.083 of the Texas Government Code.
All right, so the state is saying that they could not allow you to electronically duplicate, copy, or photograph based upon Title 28 of the Federal Code and also Chapter 4 of the Government Code. What is your response?
Several things. First, we do not believe that those provisions prohibit a defense lawyer from taking possession of the criminal histories for the purposes of defending a man at trial. That is not the purpose of those laws. That is our position. Secondly.
All right, let me just stop you for a moment. When you say taking possession of it, what do you mean by it doesn't prohibit you from taking possession? What is your definition of taking possession of the NCIC, TCIC, as you see it?
A lawyer should be able to keep the paper with him for the course of the trial so that it can be read, it can be understood, and it can be researched further.
All
And
right.
none of those things were able to be accomplished. I was unable to finish reading the histories. I was unable to digest their contents or understand them or make any meaningful use of them. I was unable to copy them so that I could do that when we weren't in court at recess at any point.
All right, so when you say taking possession, you mean keeping the paper. And when you say keeping the paper, for the record, we're talking about the NCIC, TCIC. When you say keeping the paper, do you mean leaving the courtroom with the paper?
I mean, right, I could not leave the courtroom with the paper. I could not photocopy the paper. I could not make use of the paper. And we had to give it back at the end of the day or at some point during the process. I wasn't able to read or digest the information while I was participating in my other roles as being Mr. McIntyre's lawyer. Counsel said it was handed prior to jury selection. That sounds right. I don't have independent recollection of the day, but we were involved in jury selection for all day and into the evening. It was a lengthy process, and so there was not an opportunity to make any use of it. Also, I can just say, Your Honor, in both federal and state trials that I have participated in, I have never had this issue come up before. I have had prosecutors with the Department of Justice hand me the Jenks material, which would include the criminal history material, prior to the commencement of trial. I understand that the Jenks Act similarly narrows that compulsory moment of disclosure to when the witness is passed for cross-examination, but almost every judge in the United States has recognized that while that law may be that that's when it must be produced, that isn't a fair system. It doesn't provide for meaningful cross-examination.
Okay, then somebody needs to change the law. And counsel, I'm sure as you're aware, sometimes people do things that are inappropriate legally, but they do them and nobody ends up saying anything. Nobody ends up charging anybody within anything. But in this court, I'm just here, Mr. McIntyre, to listen to arguments and follow the law. That's my role here as far as this case is concerned, because the jury trial is the parties that made the decision.
But Your Honor, what I'm saying is I don't think that the law has to be changed because I don't think that the law comes to this conclusion. I think that the conclusion the state's asking you to draw from it is not what the law means in its full synthesis, and that the court's responsibility is to allow the lawyers to be able to provide a meaningful defense to the defendant, which includes having access to the impeachment material that is involved in the case. And in particular, Your Honor, what I think we also need to draw clearly is that this isn't just about the general frustration, although there is that general frustration of not having the ability to use that information and have it on counsel table's desk at the exact time that we are in cross-examination or preparing the evening before with that information. Those things all occurred. And so there is a global harm there. But the specific and acute harm, and the reason why a new trial should be granted in this case, is because, as ground two establishes, we have a situation here where the prosecution has misrepresented the criminal history of its most important witness and did nothing to correct that record, even though the very documents we are talking about here, the TCIC, NCIC records, are the proof that it was a misrepresentation. And so that's what really ties this thing together, is that the TCIC, NCIC is being used as both a shield and a sword against the defense. And that's not its purpose. That's the bigger overarching issue here. And certainly with respect to both constitutional law, as it pertains to what due process of law for a criminal defendant means, and in terms of the full synthesis of why these laws exist and what their purpose is and how those things are supposed to operate, it simply is not the case that the court could not authorize the defense to have access to that information during the proceedings. And we were amenable then, we told the court we were amenable then, that we would have taken it under protective order. But that option was not explored.
All right, so with regards to the defense request for a motion for new trial under point one, that will be denied. Point two, misstatements of the prosecution in closing argument. What misstatements?
The state in closing argument told the jury that Joanna Reyes should be credited with belief because she had abided by the conditions of her bail on her tampering case, on her capital murder case, and had not done anything illegal, had not broken the law. And we quote the argument verbatim in the motion. We approached and explained that's just simply not true. Joanna Reyes, after she was charged in Mr. McIntyre's case, and after she entered her plea of guilty to tampering with evidence, and after her sentencing was held at abeyance and postponed pending the outcome of Mr. McIntyre's trial, she went out and obtained criminal conviction for the felony offense of credit card and debit card abuse. She was also arrested and charged with unlawful carry of a weapon. That case was dismissed because she pled to a different offense. We've included all of those records that we've obtained from the Harris County clerk as exhibits in the motion for new trial, which we'd ask that the court receive. We also made a bill of exception at the trial of the judgment of conviction for credit card and debit card abuse at the sentencing phase of the trial, which we'd ask the court to take under consideration as well. There's just no question that the state told the jury something that isn't true. Now, listen, I think Jason Garahan is a very reputable, honest, and hardworking prosecutor, and I have immense respect for him. I don't know why they said this, but it's just not true. It's objectively
All right,
false.
response.
Well, Your Honor, with respect to the statement, I trust that their motion states what I said during argument, which is closing argument during the guilt innocence. And what it may be, slip of the tongue, or the fact that I misstated that Joanna Reyes had a, I don't know exactly what was said, but alluded to the fact that she didn't break her bond is something that can be argued that it was done by mistake on my part. That may be, but the fact remains is that the defense counsel knew about this and did not bring this up during her cross-examination. And the fact is that the jury is well aware of her credibility, or credibility issues, if you may, of her being a co-defendant to a capital murder, and of her testimony that she gave during the portion of guilt innocence. And touching on the subject of the prior judgment, defense had every opportunity to recall Joanna Reyes onto the stand during punishments, which they chose not to do. And, if they consider our duty or their duty, the fact is that their client was the one that was facing 5 to 99 years of life, and they could have called back Joanna Reyes and questioned her on the subject, and they chose not to. That fact does remain there, Judge. So that's the state's position on it.
Judge, and just one more thing, closing arguments are just that, arguments, they're not evidence. And the jury was instructed about that multiple times. And so that would just be another argument regarding that.
All right, with regards to point 2, the motion for new trial will be denied with regards to point 2. All right, thank you.
May I be excused, Your Honor?
Yes.
I guess, well, we don't need the other. I'll be filing an amended notice of appeal to include the denial of the motion for retrial.
Sure.